Happy Friday.
This meeting is being recorded.
Okay. As you guys join, hopefully you'll be seeing that alert that we are in fact recording this webinar. And so if you would like to rewatch it or want to share it with some of other members in your company, feel free to reach out to the NAI staff, and we're happy to share this recorded webinar with you. I'm Farah Zaman, and the GC of the NAI, and very excited to bring you the first of what will be a series of webinars that will continue in 2023 for members only, to really help tackle the rapidly changing environment that we're all in. To that end, if you have any issues or topics that you'd like us to cover, please feel free to email me directly, and we're working on putting together that programming schedule for next year. I'm going to do a couple quick housekeeping notes, and then we'll turn it over to the Kelley Drye team. The first is everyone is welcome to use the Q&A function of Zoom to submit questions to our panelists. They'll be reading it and incorporate answering your questions throughout the panel. So again, if you have any questions, feel free to drop it there. If you're feeling a little shy today, you can drop them anonymously. So it's up to you however you want to submit those. We're also very grateful for the Kelley Drye team putting together this programming, and it qualifies for CLE credit. So if you would like to get CLE credit for today, in your registration confirmation, you should have received a CLE form, but we're also going to drop that in the chat right now. And you will need to enter a code that the team will be providing during the programming. So make sure you stay tuned in order to get that CLE credit. I already mentioned that it is going to be recorded. And I think with that, I will turn it over to our distinguished speakers. We're really excited to be joined by Alysa Hutnick, Laura VanDruff, and Aaron Burstein over at Kelley Drye. So thank you all so much.
Thank you, Farah, and thanks to NAI for having us do this. I will just emphasize, we really want this to be as practical and as useful to members as possible. So I encourage you, use the Q&A. We'll really try to make it kind of giving those very concrete examples on some of these concepts. As Farah mentioned, there's going to be other webinars. And so as you're thinking, does it help to go down deeper on certain issues, on certain topics, fold in some of the other state laws? So those are all really great ideas. We can, where we can incorporate some of that into the Q&A here, but we want this to be as helpful as possible. And so with that, we're not doing the whole waterfront on CPRA. We are focusing on a few particular issues that we found with clients have been particularly thorny. And as we're planning ahead, and we're working on compliance, how do you really think through some of those and getting some options in front of you all? So with that, I don't know if Aaron, you want to get the screen up and ready?
I do, but I need permission to share screen if NAI could help with that. Sorry, I didn't notice that before.
No problem. So while we're waiting for that, we'll give a kickoff with the overview of the topics that we plan to cover today. And then between my colleagues, Laura and Aaron, we are going to divide and conquer among the different topics. Terrific. So question number one, when do I need to comply? There's been a whole lot of just different interpretations on, is it January and I'm giving up all my holidays and it's this race to the finish line by Jan 1, or is it really July? And what is January? What is July? Are there some just really discretionary options to think about on that timing? So we'll walk through that. We are going to get into service providers, and hopefully nobody will have too much heartburn during their lunch as we walk through that. We're going to talk about notice at collection, because that is incredibly important when we're thinking about CPRA as an opt-out framework. We're going to talk about what is a sale versus a share with some, again, concrete examples. And we're going to talk about GPCs, opt-out signal compliance, and some of the recent changes to the last version of the regs and how to interpret that. And then what next, right? What do we think about when, even if we've made this distinction between January and July, what are things breaking it down by quarter where there may be some emphasis of certain efforts as we move forward? And so some ideas on how to think about it. With that, we'll move on to the first substantive slide, and I'll kick it over to Aaron.
Great. Thank you, Alysa. Thank you, NAI, for hosting us. And thanks, everyone, for joining us this afternoon or morning, whatever it happens to be where you are. Picking up on the first topic that Alysa mentioned, the all-important question of when do I need to comply? there is, in my mind, confusing language that's associated with the CPRA as a ballot initiative, when provisions became effective, when they become operative. But what we want to focus on for practical purposes is the text that is highlighted in the box at the top of this slide, which simply says that provisions that are added or amended by the CPRA are not enforceable through civil or administrative enforcement, that is by the AG or by the CPPA, until July 1st, 2023. And those enforcement actions only apply to conduct that occurs on or after July 1st of 2023. So in effect, we continue to be in somewhat of a transitional world where the CCPA as it exists today continues to be in effect, continues to be enforceable by the Attorney General. But then on July 1st of 2023, we flip the switch and everything in the CPRA and the CPRA regulations will become enforceable. So over the next 6 months, we sort of have this additional time to transition due to the structure of enforcement that I went over at the top of this slide, which I think provides a little bit of a buffer to continue getting ready for this complex undertaking of complying with all of the changes that are in the CPRA. And just as a side note, I don't want to forget to mention, as you all know, but just to underscore that Virginia, the Consumer Data Protection Act goes into effect also on January 1st, and then Colorado, Connecticut go into effect at mid-year. We're focusing on CPRA today, but we just want to keep sight of the other things that are in the mix along with California. So moving on from there to our first real substantive topic, it has been incredibly important over the first 3 years of the CCPA to understand service provider relationships for many of those in ad tech or digital advertising in general. Knowing when you're dealing with a service provider or acting as a service provider is fundamental to compliance. It determines whether transfers of personal information are sales or not. Some things stay the same under the CPRA, but there are some additional requirements. So just to go over where we are now, as many of you know, there needs to be a written contract in place to establish a business to service provider relationship. Service providers have to be bound by certain restrictions in how they can use or disclose personal information that they receive from businesses or collect on behalf of businesses. And that includes not selling the information, not retaining or using or disclosing it for purposes other than what the contract engages the service provider to do, and then not using it outside of that service provider to business relationship. The regulations that are currently enforced, the CCPA regulations, provide a little bit more detail about uses that are permissible for service providers to make. And importantly, that includes internal use to improve the quality of services, with the limit that using a business's data to sort of either to create profiles about consumers or improve the quality or clean up data that the service provider maintains for its own purposes, that's not allowed. But some internal use is allowed for quality improvements, as well as for for security. I think those are some of the two of the big internal use type of permissions that the current regulations provide. Things get a little bit more detailed and a little bit more complicated under the CPRA. We have the same basic structure. You need a written contract. We have these 3 key restrictions on service providers, but then the CPRA adds a 4th, which is to say that service providers can't combine personal information from multiple businesses unless that combination fits within a specific business purpose. Or is otherwise permitted by the CPRA. So that's a general statement. There's an important caveat that I'll make next about business purposes. And that caveat is that cross-contextual or cross-context behavioral advertising, CCBA, is categorically ruled out as a business purpose. A service provider cannot provide CCBA services if you're performing various types of targeting or helping out in certain ways that I'll go into on the next slide. You're acting as a third-party recipient of information from a business, not as a service provider. So that is one thing that the CPRA makes clear. The California Privacy Protection Agency has also emphasized. And so this is causing a lot of examination among our clients and within our practice about whether a particular service counts as CCBA or not. And as with everything that has gone on up to this point with service providers, it becomes very fact intensive. Specific relationships, specific services require close scrutiny. There's really just no getting around that. And I think a lot of the pain of doing it is probably front loaded because there's a lot of gray. We're still waiting for additional guidance from the CPPA, and there's just no getting around that fact. A couple of other important additions to service provider contracts under the CPRA is the inclusion of audit and remediation rights. These sort of track what we see under GDPR, so they're somewhat familiar in that regard, but again, we're sort of waiting for further details from the regulator in California about what they're looking for and practically what they're expecting from companies to do. And then the same applies to due diligence requirements pertaining to a business's examination of and oversight of its service providers to make sure that they're really capable of and in practice are following the restrictions that they're obligated to follow under law and under contract. I think on those last few fronts, the NAI certainly has a lot of experience in setting up structures and standards for companies to follow, and that's certainly someplace that that experience could come in to be incredibly useful in this dynamic and complex new environment that we're in. So just to underscore the point that I made about the mutually exclusive relationship between service providers and CCBA, this bold text statement at the top that a service provider cannot contract with a business to provide CCBA, that's written into the regulations, which are still in draft, but I would not expect that perspective to change. So what does that mean in practical terms about what service providers can't do? Anything that falls within this fairly broad definition of CCBA within the new statute in California, anything that involves targeting based on activity across different businesses or differently branded sites apps or services. That includes, in our view, targeting based on individuals' interests, retargeting, because that is activity across different sites, and also segment creation, because that takes into account interests that are based on activity, again, across a bunch of different sites or services. So I know that there are many different variations on different specific services that companies offer. Things don't always break down clearly along one line or another. So again, that goes back to the fact that these are fact-intensive determinations, and we really need to be careful in figuring out whether something falls into the CCBA bucket or not.
And Aaron, I might just add on that one point, as we're thinking about it, as you know, particularly for those close cases, think about who is interpreting this. When we were handling California AG investigations, you know, they were not really open to having a change of heart or mind. And so I think we can anticipate the CPPA is probably going to also take that kind of view. And so on those close calls or on those pretty aggressive takes, I guess the question for the business is whether you want the sustainable position or do you want a position that kind of gets right to the line, but very well may need to change over if there's an investigation or any pressure put by the regulators. Sorry, go ahead.
Yeah, no, excellent point. And, you know, I think one other issue to keep in mind as far as the regulator's perspective is concerned is that classifying sort of the type of service is important. We also get into judgments about whether companies are sufficiently, you know, similarly branded to count as a single business, or whether affiliates are going to be differently branded and really qualify as a business to third party type of relationship. So, you know, again, I would look at that from the perspective of a regulator that is pretty focused on enforcing sale-related provisions in the law. We certainly know that that was the AG office's focus, and I don't see any different signals coming from the CPPA. So again, something to factor into account of gauging how aggressive an interpretation of affiliate relationships might be. So what does that leave behind for service providers to do under the CPRA? I think everything has to relate back to identifying a business purpose or purposes that really offer clear support, or as clear as we can find, for engaging as a service provider in a particular relationship. So having that list of business purposes in 1798.140 handy is probably something to consider, you know, tacking up next to your computer screen. But for things that really specifically relate to advertising, we flag a couple of the purposes here. Short-term transient use, again, for non-personalized advertising, as well as an entire business purpose of providing advertising services. But just to emphasize that purpose explicitly rules out CCBA, that again is written into the statute itself. So that covers the lay of the land on the types of advertising services that service providers can engage in. We know that there is also a lot that goes along with advertising that doesn't necessarily involve the selection or delivery of ads, but things that go around it, either before or after those ad impressions are delivered. And that raises the the issue of how do we read and interpret these limits on combination under the CPRA. And specifically, really key use cases are measurement and frequency capping. And the whole analysis of how those relate to combination, I think is, it's certainly a very important and complicated question for the industry, one that we're working through with a lot of clients, but I think that the analysis really tracks back to finding whether a business purpose supports the combination, and whether any additional guidance from the CPPA in the course of developing its regulations clarifies whether these really fundamental use cases are permissible for service providers to engage in. I think that just in practical terms, we're seeing some movement and greater willingness to accept limitations on use of data to fit measurement and similar services within the service provider category. But again, that's something that we're really seeing worked out in real time. So with that, I will move to the next slide, which Laura will take us through a little more detail on the discussion of contracting.
Right, thank you, Aaron, and thank you for that overview, which provides really useful context. It's no surprise to anyone on this call, if they're involved on the business side, that there's just a lot of swirl around contracting. We're advising our clients every day on updated terms, particularly on the service provider side, because this is just this is happening very quickly as January 1 approaches. And so with the context that Aaron provided, particularly around the need to have a written contract and the requirements under the statute and the proposed regulations, the terms that a service provider be bound by, we're seeing just a flurry of new terms in the market, and not all of them are necessarily lining up. It's really requiring attention from market players. The messiness is inevitably going to sort itself out. And as we saw with GDPR and CCPA, some companies are posting their terms publicly, which will be valuable for benchmarking as entities continue to update terms. On the due diligence side, the statute does provide what is effectively an affirmative defense to violations committed by service providers and others to which a business discloses personal information if the business doesn't have actual knowledge or reason to believe that the entity intends to commit a violation. The proposed draft regulations add a new twist by strongly encouraging businesses to perform due diligence. First, the regulations give the business the right to take steps, including manual reviews and third-party assessments or audits to ensure that the data the service provider receives under the contract is processed consistently with the business's obligations. Then, in a not at all subtle nudge, they warn that if the business never enforces the terms of its contract with the service provider or never exercises its rights to audit or test the entity's systems, the business may not be able to rely on the defense that it did not have a reason to believe that the entity intended to use the personal information in violation of the statute at the time the business disclosed the PI to the entity. So while the proposed regulations don't expressly impose an affirmative due diligence obligation on businesses, it's a shove in the diligence direction, and relying on contract terms may not be enough. Now, how this shakes out in terms of a standard remains to be seen, but NAI members will necessarily be ahead of the curve here because you've subjected yourself to voluntary annual assessments. And Lee, I see that you're on screen here. Did you want to weigh in?
Yeah, thanks, Laura. I'll just do a little, guest spot in your webinar and say, yeah, this is something that the NAI is looking at and will continue to look at over the course of maybe the next few months. We already know a lot about your businesses based on our compliance reviews, and evolving those compliance reviews to help companies assess their ability to rely on contractual terms and whether or not they're actually doing the things that those contracts say will definitely be a value that we can provide to you. And so I would say stay tuned to the NAI's working groups and announcements so that you can weigh in to help us get this right. Thanks, Laura. I'll let you guys.
Thank you,
going.
Lee. Okay, well, with that, we will turn this back over to Alysa for notice at collection.
Thank you, Laura. So notice at collection was a thing with CCPA. We had a couple cases where the California AG enforced it, and it was essentially that little mini executive summary, could be a link that you had to post. Really, they generally enforced it mainly with like forms that you were filling out. Well, notice that collection got a whole big spotlight because in CPRA, there is such an emphasis on limitation of purpose and making sure that how data is being collected and used really fits within this standard. And that's set out first before we even get to the notice at collection requirements. And so we've emphasized here, not the primary use, but really for this category of other disclosed purposes, when that's okay. And it is very circular language. If you've read it, you probably had to read it maybe 5 different times and still are scratching your head. But I think the distilled version of it is that you have to have a notice at collection. The publisher would have to have a notice at collection, and it would have to talk about the other reasons why the personal information is collected and used. It's got to fit within reasonable expectations. But now that test gets really granular in terms of the purpose for how the data is being used, the context, so the context of the site and how the presentation of the disclosure is set out, what the language is. And then they add the not so helpful, it's a nexus to the primary purpose. That's really relevant. The only not so helpful example that they point to is a business purpose. And so clearly it doesn't have to just be a service provider type of processing, that there is other disclosed purpose that should work, but they leave it open and they really just emphasize, gosh, that disclosure is going to be really, really important. So I think that's just one thing to keep in mind. It's a July thing. I'll just emphasize that because we're still working through what this ultimate notice at collection looks like. But we're asking ourselves much more of the test on, is this plain language? Is this something that a consumer is going to know? Third parties, right? If we're outside that service provider definition, is it something that a consumer reading this language is going to understand that others are involved? And if this notice at collection, if this disclosure is not sufficient, if it's not effective, or if it's not provided, then the CPPA, the AG can effectively point to, well, then you're not allowed to collect it. So that's where it's just a lot of emphasis, and we'll get into, with that as background, what is in the notice at collection under the CPRA. So next slide. So we started with 7002 for 712, right? It's a timeliness. It's got to be at or before that personal information is collected. This is largely going to be on publisher sites. We have what we had before in terms of describing the categories and all the different purposes and the fact of if it is sold or shared. I'm going to highlight that because, as we'll get into in some of the later slides, there's still a tension in the marketplace with some companies not wanting to say if they sell information. Maybe they'll say if they share information. So that's a point A. There's a requirement to talk about the retention period or the criteria. That's a new thing. So that's something we don't typically see in many notices today. You've got the links to the opt-out links and the privacy policy. If you meet all this, it is an opt-out framework. And there is emphasis to that. I think there's also a lot of confusion in the marketplace on, is it really opt-in? Did the regulations turn it into opt-in? We're seeing some companies choose to do opt-in cookie banners. It may be because they're applying GDPR more broadly as a global approach. It may be that there's confusion and just nerves, honestly, around the ability to use this information. But I think we are going to see some variations there. I think we're also going to see this notice at collection link, less so in the Q1, but as we get closer to kind of getting to July, probably a separate notice at collection link, as opposed to necessarily going to the deep link to the privacy policy, because in today's standard, this notice at collection is a paragraph and you can have it at the top of the privacy policy. So if you click on the link to the privacy policy, you go right up to the top, you see it. This notice at collection under CPRA is a pretty detailed chart at the end of the day, because it's all those other disclosed purposes and having them be plain language and really clear. So I don't think it's necessarily magic language that we've never seen before. I think the presentation of it starts to look a little bit different. So next slide. Thankfully, let's focus on the positive. The latest version of the regulations softened this really vexing requirement that had been in the prior draft of really detailed disclosures about the third parties that control. And that is kind of the very pointed concept that there are sales and shares going on with somebody else on your site, another entity, in terms of the data that they collect. And so there's still an acknowledgement that there is more than one business potentially that may be controlling the collection, determining the purpose and the means of how that personal information is collected on a publisher site. And that they both of those entities have a transparency obligation, but you can have that reflected in the notice at collection on the publisher site. There's also some less than clear examples, but ultimately saying, you third party, you still have a transparency obligation. You've got to meet your own disclosures on your site at the very least. So there's not a requirement that you need to list all the names of the third parties. That was something that I think a lot of us thought was never going to actually be practical, but you do still have to meet the substantive transparency obligations, both on the primary site and then the ad tech participant site. So next slide. So how do we distill what's the takeaway from notice at collection? Disclosures, disclosures, disclosures. And it's not just long legalese and kind of taking the old version of the privacy policy and automated data collection and thinking that just works. I think it's time to just take a fresh look, and where can we be even more concise, but more clear, and presenting that in a way that doesn't necessarily look like lawyers wrote it. And so getting something that is both appealing to the eye, it's easy to read, it's easy to understand to the extent possible. And if you do that, it's opt out. If you don't do that, it's opt in. For those who may be really conservative and nervous, they may choose some variation, may do opt in as well. And those who are doing kind of a national approach, even outside of California, and really wrestling with sensitive personal information, for example, there may be some things that are opt in that also warrant robust notice. So it's really figuring out how to harmonize those different obligations. Are you in an opt-in bucket by necessity or by discretion, or not at all, in which case it's opt-out, but making sure all the things really supporting that opt-out approach remain the case. So I know we have a question here. And Laura, I know this is flipping back, but since it's still relatively present, how can we limit the audit clause to the maximum in a service provider? And I know you're typing, but maybe we just.
Yeah, no, I mean, it's a good question. And so, yes, I was typing and listening to you at the same time. But I think that, I mean, the draft regulations are likely to, I think, stay as they're written here with respect to requiring that service provider agreements provide an audit right. And so where parties have negotiating leverage, they can negotiate this, that provision to require for more or less. But if they don't, then very likely that provision is going to be difficult to negotiate, is what we're seeing with our clients. I'm curious whether you or Aaron have other thoughts.
No, I think that's right. And I think you are going to see a lot of different versions of that. And it's, it's just going to be another experimentation. You're going to have some who are going to try to go obviously as most aggressive as they can. And it's another just point until it settles out, probably in a year or 2 years. But I think, we've seen this in data security years back. So just not everything has to be reinvented entirely anew. And so we can pull from past examples. That's usually pretty helpful. One point I didn't make that I mentioned, obviously disclosures, icons continue to be really important, and it doesn't all have to be in words. It, colors, visual presentations to draw the eye, as we've done in the past in the marketplace and within self-regulation. And so, it's a good question whether our current icons start to evolve and we start having other just standardized ways that we might ultimately disclose this. And I think that's, it's a reckoning for the industry on whether some things get updated to help support industry members in meeting these obligations. And I know, we'll be talking about this in terms of the trade associations, but like, how can we even be better and modernize that given these new requirements and what they mean? All right, so I think I've hit at this, but you might be scrolling and looking at websites to see some market examples of notice at collections. I think they're going to be slow coming out to what this version under CPRA really requires. I think we'll see some things in cookie banners more, notice at collections. I think we start seeing some detailed charts as we get closer. Ideally, there's an industry standard, and I know that there's a lot of efforts, and there will be continued efforts to see if maybe we can get there, and have some, here's the language in the contract that really goes to that point, and we start seeing some consistency, because that's good for businesses, it's good for the industry, and it's good for consumers if they can recognize and it's the same kinds of language. So that's the goal. It's going to take some work to get there, though.
Alysa, we have an interesting question that's related to what you just observed about seeing variation and notice at collection. And the question is whether updated privacy policies are required January 1 or whether that's a July 1 requirement.
Sorry, I was even looking at the second question. The privacy policy for CPRA. So if we go back to, we don't have to flip the screen, but anything that CPRA amends CCPA is enforceable July and after. So I think technically, right, that you have CCPA privacy policies, which do require an update at least annually. I think you have a lot of companies wrestling with, they need to do the annual update. They also need to account for Virginia. And so choosing to make perhaps lighter updates, if they're not really ready to roll out all the rights, if they are ready to roll out some of the other rights, then you see more of those CPRA optically in the privacy policy. But I think you've got some room and discretion depending on where you're at with a roadmap to July on that front.
Just one other point I'd add on that, keeping in mind Virginia and its regulation of sensitive data, that might also be an area where if you're updating sooner rather than later, you'd want to start incorporating that into a January or January-ish update.
That's a good point. On the second question, is notice at collection really kind of this GDPR analog? And we all have our CMP images, which we continue to see on breaking up the cookies by category. Is this really just that? And I think while a lot of the tools available still hearken to GDPR, cookie categorization, the format, yes, the substance, we're not in GDPR. And so if we just kind of bolt on CPRA, that modal banner preference center looks really detailed and has a lot of other stuff. And so the question is really, can we fresh look, have what we need for US, and you actually get to something a lot more simple, but it takes some work. And so we're going to continue to see some just different flavors of that. But I agree. I do think it's getting something in front where somebody can both opt out or they can revisit their choices. And there's now going to be a lot more choices. So a preference center does start making a whole lot of sense, even if it's not explicitly required. Next slide.
Hey, Alysa, this is Lee. Can I just ask another question about that? How, if we're going to have cookie banners that are kind of separated, I know folks are hoping for kind of a one-stop shop global approach, but if you don't need the detail in a cookie banner, but you'd still like to use a cookie banner for your notice requirements in California, and then therefore you have multiple banners, how are companies generally tracking that? Are they using IP addresses to determine California versus European users, or is there any, I'm always looking for the golden bullet, but I think that's the right approach, but is there any other way that companies are doing it in your experience?
Yeah, no, I mean, geofencing IP address, and that's, you need a reasonable basis to identify the person as a resident of that state or that jurisdiction. So I think less than perfect, but I do think IP address is largely used. I've seen some, maybe a different version of that is either have the cookie banner, have the links on the footer, you click that link and it takes you up, and it's that page then that might differ via jurisdiction or might lead with jurisdiction. So I think operationally, the question is really what works best for you, whether you're building it yourself or you're using a CMP to do that, knowing that you're going to need to continue to make updates. And so what is a way that can be efficient to make updates as we have to tweak the language and we might have to expand the jurisdiction. And so thinking through like that. I'd also just say if using the cookie banner or the modal, making sure that they work. I mean, that they work under different browsers, different considerations. You probably remember like one of the scenarios that the California AG enforced is that it wouldn't work if you were using a browser that was blocking cookies. So it's also just making sure whatever tool you end up using, really lean into the good faith, but also like periodically pressure test to make sure it's working as intended. All right, so I think, is this a Laura or an Aaron slide? And it might be me, in which case I will
think it's you. Yeah, sorry.
Okay.
Sorry to keep you
So
out.
yeah, no worries. One of, so on sale versus share, sale obviously was like the loaded term, and we got there. And if you weren't, if there was any ambiguity over it, Sephora very publicly identified what the AG's view on that was, right? That it's money or other valuable consideration, which was a lot of ad tech, unless you really could fit it within a service provider context and set of restrictions. So share, we now have this subset, a lot of us view it as transferring it for CCBA purposes, even if there's no consideration. And that was, and there's some commentary by McTaggart and others leading up to it, basically pointing to the interpretations of CCPA and saying, all right, well, they were taking a really kind of narrow view. So therefore, that's why we did the ballot initiative and making sure there's no avoiding a sale or a share. And you have this anti-avoidance language towards the end of the CPRA that just reinforces this, right? Like as they interpret whether a certain practice is a sale or a share, they are looking at each of the chain of activities along the way. So you take a pseudonymous identifier, and maybe in that one connection, the entity may not know who it is. But if the ultimate purpose of using that identifier is for targeted advertising, I think we have a good sense of how the regulators are going to look at that. Okay, and so by definition, as Aaron mentioned, you can't be the service provider offering CCBA. And so the nexus to what the services are to CCBA is going to be really, really important, and creating some space there if it's really important to be a service provider, that you're not teeing up, you're not facilitating, you're not activating audiences, because that is likely to not be considered reasonably as a service provider by these regulators. All right, so then we get into opt-out preference signals, global privacy, formerly known as global privacy control. And we're not going to go through all of the different versions of this. What we really wanted to highlight here was the new language that we've got in red, right? So the business shall treat the opt-out preference signal as a valid request to opt out for that browser or device that we knew. And here's the new part, and any consumer profile associated with that browser or device, including pseudonymous profiles. The second part, we knew that essentially, if you were doing identity resolution, then you had to persist it for that consumer. But with the red language, this question of what is the business has this obligation to honor this, not just for the browser or the device, but for the pseudonymous profile. And so it suggests, is there a cross-device obligation there? Is there this affirmative obligation to retain data to match? And if we flip to the next slide, I think it's really important to compare this regulation language with this language in the statute, right? So the CPRA says you don't need to re-identify or otherwise link information, where in the normal course of your business, you don't maintain information in a manner that would be considered personal information. They don't call this de-identified, right? They don't specifically say it has to meet a de-identified standard. So I thought that was really interesting and is something to consider as you evaluate your business practices. There is some subjectivity there. But the second one I think is also really, really telling as well, in that CPRA should not be interpreted to force you to retain personal information if your normal course of business would not. And that gets into persistency if you are doing data minimization. And so while yes, supporting compliance, really thinking about what are the reasonable limits to what you need to do, what ends of the earth you need to do to be able to persist a GPC. And I think there's room for good faith and for error here, and it certainly will evolve. But if there's a takeaway, I don't think we need to be running to get to the cross-device solution by July. I think, there certainly will be innovation and we'll see what comes from that. So it's not static by any means, but there's not this very, very high threshold that I think all companies under the law are forced to get to immediately. I wanted to flag that 3 is not so helpful because verifiable consumer request here is defined really not to include the share and sell rights, right? It goes back to where the other rights where you have to validate identity, verify identity. So it's really the J1 and 2 to be thinking about in terms of if you need some reasonable limitations to the scope of how you honor your GPC.
All right, well, continuing along the lines of handling consumer requests, this is another area where the CPRA expands the obligations that businesses have under the law, and also expands things on down the chain from a business to third parties or business to service providers and at subsequent stages. So just to highlight 3 areas where businesses are being required to pass through consumer requests to other businesses or to third parties, those that are not acting as service providers. That includes the opt-out of sale and sharing, the new right to limit the use or disclosure of sensitive personal information. And we haven't spent a lot of time talking about sensitive personal information. One thing I think to recognize is that there is a list of permitted or sort of necessary uses of sensitive personal information that don't fit under this right. That is, if you request to limit or a consumer requests to limit, it doesn't affect a business's ability to use or disclose sensitive information for purposes that are on that list. And then the third pass-through or flow down obligation has to do with deletion, where a consumer's deletion request needs to go not only to third parties to which personal information has been sold or shared, but also to the business's service providers. In terms of implementation and the fact that a lot of data that gets passed along or is processed in connection with digital advertising is pseudonymous and may involve different stages of resolution of pseudonyms. How will all of this work when those differences in identifier management might be very important as we move from one entity to another? I think that right now remains an open question. It's a little bit different in the current environment where service providers are required to delete information, but we're again sort of seeing a lot of our clients think through, all right, how can we do this within the context of the relationships that we have with other advertising partners? And if you are receiving these flow down requests, how do you deal with them? That I think remains an open question. We are seeing a lot of emphasis on that one top flow down, right, of handling this within the context of opting out of sale or sharing as the primary focus of a lot of this work. Just to sort of bring in a more industry-wide perspective as relevant to this discussion, many of you may be aware that the IAB has a contractual and technical framework that has been developed to help on this front. The multi-state privacy agreement on the contractual side, global privacy platform on the more technical side as a way to pass signals from one entity to another. That's one way that, at least as far as opting out is concerned, is in development. So, I think that's worth mentioning, worth being aware of and examining as an example of how some of this communication between different actors within the ecosystem could work in practice.
Hey, Erin, this is Lee. Sorry, I'm just going to ask questions in here so that folks understand the context. I think there's been a lot of confusion among our members about the MSPA, which is kind of probably the subject for a whole different webinar, but between the whether or not you can use global privacy platform GPP signaling without signing on to the MSPA. So there seems to be a little bit of confusion and some either misunderstanding or lack of clarity around when you can use one, or do you have to use both? Is it a package deal? So I don't know if you guys have a viewpoint or can comment on that to give us a little more clarity.
So you don't need to be signed up to the MSPA to use GPP. Even if you do sign up to the MSPA, you can, not every transaction has to be covered under the MSPA. So you can actually designate, right? And that's really by necessity, as there's transition for other entities to have some time to sign up. But also some of your flows just may not warrant, or you have another way of addressing that. So yes, you can use GPP without signing up to MSPA. It's not a package deal.
Great question. And let me just address one other question from the audience on the issue of opt-outs. The question is, how do the opt-out of sale and share and the opt-out or right to limit sensitive personal information use or disclosure vary, or how are they different? The right to limit sensitive information use or disclosure, just depends on the specific types of information, and precise geolocation, as was mentioned in the question, is one category that might be being sold. There could be other types of sensitive information involved. Technically, those are separate rights under the CPRA. I think many disclosures of sensitive information that are subject to the right would be sales in their own right. One option that the CPRA offers is to handle them both in a quote unquote frictionless manner. That is part of the draft regulations, so that one action immediately opts out of sale and sharing and also limits the use and disclosure of sensitive personal information. I'd say that that's a stage 2 or 3 development in complying with the CPRA, but that is an option to combine them into one step. So with that, I think we'll move on just to pass things over to Laura and take a look at what's coming up next.
Yeah, what's coming up next is what hasn't happened yet, right? The CPPA has been busy. The team at NAI has been keeping this group updated on what they've been up to. The first draft of the regulations clocked in at 66 pages, and the current draft is up to 73, but incredibly, they don't include all of more than 24 topics that were required by the state legislature to have been addressed. So they're busy trying to finalize the rules that were due months ago. And they've missed some key consequential issues like automated decision-making, which here the CPRA requires the agency to issue regulations about access and opt-out rights relating to use of automated decision-making technology, including profiling. So this is it's a lot for the agency to address, and it's going to be significant to industry here. We're keeping an eye on it. Another significant rule that we're waiting to see relates to risk assessments. The statute requires the agency to, or the statute requires businesses to engage in regular assessments where the processing of consumers' personal information presents a significant risk to consumer privacy or security. And the statute requires the CPPA to put more precision around what that means. How do businesses decide that processing could result in a significant risk? That question remains unresolved. And they just haven't put a finer point on that. The statute also requires risk assessments for the processing of sensitive personal information, and we require greater clarity around that the CPPA hasn't gotten to yet. So stay tuned. Next slide, please. So this is the best part of the presentation, I think, because it not only tells us where we are and where we're headed, but I get to give you the CLE code, which is really why some of you may be here. And that code is 3126. Again, it is 3126, and we've gotten some. I'm sorry, the link is in the chat. And I see I've also got a note here. Question is there an expectation that on the open issues, yeah, that they'll continue, but not until Q1, Q2, and I think that's right. Okay, so on the timeline, some of this is self-explanatory. We'll circulate this so that you have it. You can tape it up right next to the provision of the rule that Aaron recommended in section 140. But where we're recommending that you focus your attention in December, where we are right now, thanks to that snowflake, is reviewing privacy policies. We had a question earlier about whether privacy policies were a CPRA issue. And really, I mean, they're a CCPA issue. And so we want to make sure that we have facial compliance and that we don't forget UDAP. We need to make sure that while we're thinking about state law compliance, that we also make sure that our privacy policies are truthful and not misleading, and that we are complying, that we're doing what we're saying in our privacy policies. In addition, we are updating contract terms, as we discussed with respect to service providers, but in other respects too, and that we want to be thoughtful about CCPA digital advertising, as we discussed at various points, including, as Alysa described, that the Attorney General, and we expect the CPPA, when it has its enforcement authority, will take a continued broad view of sale, as was evidenced in the Sephora settlement, and that we want to make sure that we're in compliance as relates to our practices with that. And then as we're thinking ahead to July 2023, how we are operationalizing our CPRA rights. Looking ahead to Q1, Q2 2023, we do need to think about those planned updates to July. Virginia, as Aaron mentioned, that's going to be a key issue that we need to think about. Virginia comes into effect January 1. The Attorney General in Virginia has not emphasized compliance with the statute in the way that the Attorney General in California has, but nonetheless, we have facial compliance requirements there. And then we want to promote consistency for policy rights and opt-out options for consumers. Now, Colorado is beyond the remit for today's webinar, but we'll know more about that rulemaking as it progresses there. And then we're looking ahead to Q3, Q4 as the CPRA enforcement takes place, and looking ahead to Utah taking effect on December 31st, 2023. And it's just lots more of the same, where we're going to look ahead to, really refining where we are with state law privacy compliance, and really improving upon the good work that we're doing right now and that we'll do in the early part of 2023. Alysa, Aaron, more to add on this timeline? Lee?
I can't believe we're done. We could keep going for another hour. I'm so packed full of information. So firstly, on behalf of the whole NAI family, I'd like to say thank you for this very jam-packed deck and all of the information. And thank you for humoring me with the questions. And I'll say to the NAI folks that are still on, thank you for your time today. Look for more of this. This is something that we have heard from our members, that this is what you need. You need practical, actionable, straightforward advice about what to do about all of these complex regulations and challenges. So there will be more of this. We're building out a calendar right now, and so we'll have great announcements probably right after the new year on more things to do with these smart folks and others. And then we'll use that to build guidance and helpful tools for you all as you work through these compliance challenges before July. So stay tuned, and thanks for your time. To the extent I won't see some of you, I wish you a very happy holiday season. Happy holidays. Thanks to the KD team, and great job. Thanks, everybody.